Okay. Hello, everyone, and thank you for attending the second panel of the Oxford Conference on US Senate Resolution 684 regarding the conflict in Anglophone Cameroon. My name is Hyunwoo Kim, and I'll be moderating today's conference. So if you have any questions for the speakers, for which you'll have time to ask after all the speakers have spoken, please message me, the host, on the chat functions. The speakers will be speaking in the order of Nicholas Maisel and Morgan Smith, Kyra Fox, Muya Nyundi, Professor Franz Viljoen, the Honourable Dr. Sebastian Nadeau, and finally the Right Honourable Emily Thornbury. But before we begin, I'm honoured to introduce Maggie Kilo, who will be opening the event for us. Maggie Kilo has dedicated much of her work and life to the development of countries in Africa, especially as a part of the African Development Bank, where she worked for 18 years, holding several positions in both country operations and policy review prior to her retirement. She now coordinates the women's group of Global Takembeng, whose wide-ranging humanitarian mission includes peacefully advocating for and bringing international recognition to the struggles of the Southern Cameroonians. So I've just asked Maggie to unmute. So if she will introduce herself.
Thank you very much. I hope you can hear me. Good. Esteemed panelists, distinguished ladies and gentlemen, allow me to begin with a big thank you to the organizers for giving me the chance to speak on behalf of Global Takembeng, the mothers and grandmothers of the Southern Cameroon's struggle. I must tie my heart as I speak about the terrible suffering of our people, lest I spoil my short presentation by shedding tears, just like mothers have been doing in Southern Cameroon for decades. Our suffering did not begin under the Biya regime. No. It started long ago under Amadou Ahidjo, Biya's equally cruel predecessor. These two brave sons of La République du Cameroun, supported by France, have taken from us every good thing we had, replacing our cultural symbols and institutions with Francophone ones. In schools, our children now speak and write Franglais because they are taught by Francophone teachers who hardly speak any English. Our courts are managed by Francophone magistrates who do not understand the basics of English common law nor communicate in our language. Our administrators are mostly Francophones, appointed by Biya and dreaded by our people. These governors, senior divisional officers, sectorial ministerial delegates do not represent our interests. We pay taxes to Yaoundé, and in turn, we get dilapidated roads, intermittent energy and water supply, corrupt management of our land resources, poor quality education and health services. Our children graduate from university into a life of Ben skin, motorbike taxi riders, because they are shut out of opportunities for jobs or business in a bribe-based society merely for being Anglophone. Under a reign of terror, the criminal justice system comprising Francophone gendarmes, police, and military, including the notorious BIR, the Brigade d'Intervention Rapide, have tortured our children in schools, raped our daughters, killed our sons, burned down hundreds of villages, looted and destroyed livelihoods as our communities have emptied out into the bush. An abomination among our people is the fact that mothers have become grave diggers, burying our parents, husbands, sons, and daughters while working to feed the remainder of our families locked up in Biya's atrocious overflowing prisons and dungeons. And the situation has been steadily growing worse. All because of a UN mandated plebiscite that promised we would be treated equally and maintain our Southern Cameroon's autonomy within a federal system. As the numbers of refugees and IDPs have grown and the humanitarian disaster escalated, the voices of our friends remain silent. First Lady, Madame Chantal Biya, a mother like myself, has never once raised her voice against the atrocities and killings being perpetrated against our people. And we are supposed to be citizens of a one and indivisible nation. Please, someone tell me, when will the killing stop? When did being an Anglophone become a crime? Has the United Kingdom abandoned 8 million Anglophones to be decimated by Biya and the Beer? Will the Rwandan genocide be repeated in slow motion in southern Cameroon, even after never again? Has the rest of the world left the peoples of southern Cameroon without hope? One thing I know for sure is that as long as Biya's forces are bent on killing our people because they consider us to be Ambazozos, Anglo-fou, Anglo-con, stupid, slaves, dogs, rats, and cockroaches, our children too are prepared to defend themselves until the last man has fallen. Our passion for our culture, our institutions, our history, and our English language will certainly keep us going. Thank you.
Thank you very much. Our first speakers are going to be Nicholas Maisel and Morgan Smith. So I'll hand over to them.
Hi, everyone. My name is, everyone can hear me all right? My name is Nicholas Maisel, and my co-presenter Morgan Brock-Smith and I are student attorneys with the University of Southern California Human Rights Clinic. Our clinic has been engaged in various advocacy efforts since 2017, geared at drawing attention to the humanitarian crisis in the Anglophone regions of Cameroon. We, at the outset, want to thank Dr. Willis and the Cameroon Conflict Research Group, Effie Tembon, as well as the Oxford University Cameroon Conflict Student Society for inviting us to present today and for organizing this very timely webinar. We're delighted to be speaking alongside such distinguished panelists. We're going to discuss how targeted sanctions can be a first step to holding human rights abusers accountable for their actions in the Anglophone crisis. I'm going to lay out the framework for how targeted sanctions regimes like the Global Magnitsky Act in particular work. Morgan is then going to explain how targeted sanctions particularly if implemented across multiple jurisdictions, can help address the climate of impunity that's characterized the conflict to date. and to push parties towards bona fide negotiations. So some caveats at the outset. First, we want to emphasize that targeted sanctions are merely a first step here. In our view, there's clear evidence of crimes against humanity being committed in the Anglophone region since at least 2017. And those crimes need to be thoroughly investigated. The international community should consider setting up a commission of inquiry similar to that created for Burundi, for Myanmar, or Syria. And the International Criminal Court should seriously consider opening a preliminary investigation into crimes against humanity and war crimes that fall within its jurisdiction. That said, sanctions against human rights abusers under laws like the Global Magnitsky Act in the United States should form part and parcel of the international response. Sanctions are especially attractive in that they don't depend on the complex international political dynamics often associated with establishing mechanisms like commissions of inquiry. And they don't entail the cost and time delays that are often associated with litigation. There also seems to be a real willingness on the part of governments to use human rights sanctions in this context. The US Senate Resolution 684, for example, explicitly calls for sanctions against human rights abusers in the context of the Anglophone crisis. So, how do targeted sanctions for human rights abuses work in practice? Obviously, there's variation between various jurisdictions. So there are laws allowing for such targeted sanctions currently in the United States, the United Kingdom, Canada, Australia, and at an EU level. Each of those is worded slightly differently, and obviously the agencies in charge of implementing sanctions are different in each jurisdiction. But on the whole, these laws allow governments to impose sanctions against individuals they determine are credibly involved in serious human rights violations. So here, the US system is a good exemplar. It was created by the Global Magnitsky Act in 2016, implemented in 2017 by executive order. It allows the US government to seize assets and impose visa restrictions on persons that the US government deems are leaders or officials of entities involved in serious human rights abuses. Those determinations are made internally by the US Department of State and the US Department of the Treasury, but those departments solicit submissions by civil society and non-governmental organizations, and those submissions often form the basis for the imposition of sanctions. So there's three aspects that we think are particularly relevant with respect to the US targeted sanction system for the Cameroonian context. First, laws like the Global Magnitsky Act allow for the targeting of both government officials and non-state actors. So there's no state action requirement for the imposition of sanctions. Second, the Global Magnitsky Act and similar laws allow for sanctions against third parties who are deemed to be acting as agents of a human rights abuser. So in other words, it would allow for sanctions to be imposed on family members or on corporations that are wholly controlled by a human rights abuser. And then finally, the term serious human rights abuses, which is the keystone for the imposition of sanctions under the Global Magnitsky Act, regroups torture, deprivations of life, and deprivations of liberty. In other words, behavior that's been credibly attributed to government forces and security forces operating in the Anglophone regions of Cameroon since 2017, as well as to certain non-state armed groups. Those features seem to have been replicated very closely in other jurisdictions. So the UK global human rights sanctions regime, for example, also allows for asset freezes and immigration restrictions against persons involved in serious violations of protected rights, which also regroup the right to life, the right to be free of slavery, and the right not to be subject to cruel and unusual treatment. That language is also mirrored in the EU sanctions regime, although we have yet to see sanctions put into place at an EU level. So with that, I'm going to turn it over to Morgan so that she can discuss why we think sanctions can be so effective in the Cameroonian context.
Great, thank you so much, Nick. So as Nick said, we're going to turn now to why sanctions can be particularly effective in this context. We want to emphasize once again that we really don't view sanctions as a substitute for further accountability measures. However, we see sanctions as taking the first step towards ending impunity. And in particular, we feel it is important that sanctions are imposed on perpetrators on both sides of the conflict in order to be truly effective. That is, sanctions should not be mistaken as a political endorsement of one side over the other. So as Nick touched on before, the benefit of targeted sanctions as we see it is that they can be implemented quickly and precisely. This is important because the conflict shows no signs of slowing down. Thus, there really needs to be international pressure now on both sides of the conflict to consider peaceful negotiations. In addition, sanctions can be directed against those who bear the most responsibility for directing human rights abuses to send a clear message. And finally, due to their precise nature, targeted sanctions don't entail the same heavy humanitarian costs that are often linked to generalized sanctions regimes. So we believe that sanctions can have a real impact in de-escalating this crisis for a few reasons. For one, there are the potential practical implications of sanctions. Many government officials have assets tucked away in Western countries, and many often spend a good deal of time abroad, as do their family members. In addition, many separatist leaders affiliated with armed separatist groups are living in the United States and Europe and raise funds for these armed groups while living abroad. The direct impact of asset seizures and visa restrictions, along with the future promise of potentially having those sanctions lifted, may help deter those most responsible for human rights abuses from authorizing attacks against civilians in future, and may help them more seriously consider peaceful negotiations. Sanctions can also have a very important signaling effect. They can send a really powerful message that the international community is paying close attention and strongly condemns these abuses. They can also help to delegitimize the actors who are most aggressively targeting the civilian population, potentially leading to their removal from command structures, and may also serve as a warning to other government officials or separatist leaders that they must curb abuses or face similar repercussions. So to leave you all with a few final remarks, we would like to affirm once again that bringing both sides of the conflict to the peace table is the key goal of imposing sanctions. Any pressure that the international community can bring to end human rights abuses is helpful because these abuses have really been the biggest drivers of the crisis. The violence in the Anglophone regions may have lasting implications for Cameroon's domestic stability, and events of the past year have shown that the crisis is not nearing an end. Far from it, we have seen some of the worst massacres of the crisis in Ngarbu last February, in Kumba in October, and most recently in Mautu in January of this year. Ensuring accountability for government actors as well as separatist leaders is the first step towards stabilizing the region. Furthermore, the humanitarian crisis in the Anglophone regions threatens to destabilize not only Cameroon, but surrounding countries as well. For example, the outflow of refugees into Nigeria has created a refugee crisis there, as many Cameroonians have been forced to shelter in underfunded refugee camps in Cross River and Taraba states. In addition, it is essential that Cameroon remains capable of fighting Boko Haram in its far north region. Since 2019, Cameroon has redeployed several significant military assets from the far north to the northwest and southwest regions as part of its militarized response to the Anglophone crisis. This redeployment has allowed Boko Haram to expand their operations to the point where the group is now able to conduct large-scale operations again for the first time since 2015, placing Cameroonian civilians in the far north at risk. Unless the government of Cameroon ceases its military campaign against the Anglophone regions, it remains unlikely that Cameroon will have the capacity to support security operations against Boko Haram in future. In conclusion, we would like to hammer home the immensity of this humanitarian crisis. Since 2016, there have been 700,000 IDPs, over 60,000 refugees who have fled to Nigeria, and thousands of deaths. And as with many conflicts, this crisis has had a disproportionate impact on women and children in particular. UNICEF currently reports that 1.1 million children have been unable to attend school, and there have been reports of rape, among with other forms of gender-based violence, being used as a weapon of war. We hope that targeted sanctions can be an effective first step towards pressuring both sides of the conflict to cease human rights abuses. But we would also like to highlight the importance of coordinated action in solving the crisis. While it would be powerful to have even one government impose targeted sanctions, it would be infinitely better to have several governments impose sanctions all at once. Thus, we strongly urge all governments with appropriate sanctions regimes, including the US, Canada, the EU, as well as the UK, with its sanctions regime, which just fully came into force, to seriously consider targeted sanctions against human rights abusers in this conflict. I believe we're out of time, so thank you so much, everyone.
Thank you very much. Our next speaker is Kyra Fox from the US Holocaust Museum, who will be discussing what the concerns raised in her report about the conflict are. So Kyra, hello.
Thank you so much. First, I want to just thank you and all the other organizers for convening such an esteemed group of panelists on this really important topic, to Morgan and Nicholas for their kind of legal analysis to start us off, and to Maggie Kilo for her really important words to remind us all of the gravity of this crisis and why we're here today. So I'm really grateful to be on this panel and really excited to see all of the mobilization around this Senate resolution that passed recently in the United States. So I am part of the research team at the US Holocaust Memorial Museum's Simon Scott Center for the Prevention of Genocide. So the Holocaust Museum teaches that the Holocaust was preventable and that by heeding early warning signs and taking early action, individuals and governments can save lives. So with this knowledge, our center works to do for victims of genocide today what the world failed to do for the Jews of Europe in the 1930s and 1940s. We use a multi-pronged program of research, policy engagement, training and education, and coalition building, and focus on disrupting mass violence at every stage through 3 strategic approaches: through preventing mass violence before it occurs, through responding to ongoing mass atrocities, and then through pursuing justice and accountability for atrocities that have occurred. So our center works on a select number of cases that are currently experiencing or are at risk of experiencing mass atrocities, which we define as large-scale, widespread violence against civilians. In the case of Cameroon, we began work on the Anglophone crisis just over a year ago. Our goals with our work on Cameroon have been to, first of all, highlight the ongoing atrocities against civilians by security forces and separatist groups in the Anglophone regions, and second, to identify the further risks for mass atrocities. Mass atrocities themselves are extremely rare, so part of the work of the center is to identify the worst case scenarios and highlight the steps that conflict actors and governments must take to prevent these worst case scenarios from coming to fruition. At this stage in the Anglophone crisis, we see a regular pattern of low-level violence, which occurs on an almost daily basis, punctuated by large-scale massacres every few months, like the ones we saw in Ngarbu, Kumba, and more recently, Mautu. In the report that we published this summer, we highlighted several developments that heighten the risk that we will see even more large-scale violence against civilians in the future of the Anglophone crisis, highlighting the need for governments to take preventive action before the conflict escalates any further than it already has. So just to highlight a few of these developments. First of all, we are worried that abuses by separatists and security forces have reportedly been on the rise over the past year, with violence recently escalating after the regional elections in December of 2020. Both the security forces and separatists are increasingly targeting moderate civilians whom they perceived as associated with the opposition, and with weaker command structures on both sides of the conflict, as well as a lack of civilian oversight of security forces. This is allowing for more extreme attacks. And additionally, we're extremely concerned that both sides of the conflict continue to incite violence and use hate speech on social media, which only furthers the crisis. On the government side, we're seeing that security forces are becoming emboldened by a sense of impunity for their attacks and more brazen in their attacks on civilians, which is exemplified by the recent Ngarbu and Mautu massacres. As the crisis persists and security forces are not held accountable, they are pursuing increasingly brutal attacks on civilians, including reportedly attacking former safe havens like hospitals, health facilities, and palaces of traditional leaders. Meanwhile, on the separatist side, we see that the movement is fracturing, with some factions operating more like criminal networks and committing more extreme violence. A fractured movement makes pursuing a ceasefire or a peace agreement more difficult, And we also see separatist groups becoming better equipped and trained, reportedly capturing more sophisticated weaponry from Cameroonian security forces, smuggling weapons from Nigeria, and producing homemade bombs and IEDs, which we've really seen escalate over the past few months, and possibly projecting force outside of the Anglophone regions. And with better equipment, training, and funding, separatist attacks will likely become more strategic and inflict greater damage on both civilians and security forces, which in turn could lead security forces to double down and increase their attacks on both separatists and civilians. With all of this, we're concerned that neither side appears willing to make the concessions necessary for a political solution, and that the conflict shows indications of becoming protracted. A trigger could cause the crisis to worsen significantly. An example of such a trigger could be the death of Paul Biya, who has failed to groom a successor for a peaceful political transition. And an abrupt end to his rule could prompt a possibly chaotic and violent power scramble, which could further destabilize the Anglophone crisis. Separatists could take advantage of a power vacuum to wage further attacks, and the BIR, the elite security force, which is allegedly loyal to Biya, could escalate attacks on civilians without restraint. And so with these ongoing atrocities that we've seen, and the warning signs that the conflict could escalate and put further civilians at risk, this leads us to the question of what now? We've been grateful to see the actions of the US government, including the withholding of military aid, the reduction of security assistance, ending trade preference under AGOA, and calling for an independent investigation into Ngarbu, and most recently the passage of Senate Resolution 684. But initial actions of countries alone cannot replace the regional or multilateral initiatives and pressure to bring both parties of the conflict to an inclusive process of dialogue and resolution. The absence of sustained and priority level engagement of the UN, the AU, the Economic Community of Central African States, etc., all lessens the positive impact of one-off actions of individual nations. And importantly, solving the crisis requires a good faith effort of the Cameroonian government to address the longstanding and deep Anglophone grievances and a willingness of the separatists to come to the table. So we're excited to see the passage of this Senate resolution, which offers a number of recommendations that advance atrocity prevention efforts by addressing the risks that we outlined above at the level of the root causes of the conflict, as well as preventing actors from committing further atrocities. These recommendations include pursuing an immediate ceasefire, pursuing inclusive dialogue and independent mediation, and credible and transparent investigations into all human rights abuses. We really believe that justice and accountability are essential to ending the cycles of violence that we've seen in Cameroon, and that could look like independent investigations, as well as holding the perpetrators on both sides responsible. Further recommendations that would enhance atrocity prevention, echoing Nicholas and Morgan's call for targeted sanctions on both sides of the crisis, and efforts to engage in international fora to resolve the Anglophone crisis. There are a number of ways the United States could do this, for example, by establishing a formal investigation into the commission of atrocities in Cameroon through the UN Security Council, General Assembly, Human Rights Council, or Secretary General, or by calling for a special rapporteur for human rights in Cameroon through the UN. And I will stop there and just say that we are really grateful for the engagement of all the panelists and organizers around the Senate resolution, and hope that it spurs the much needed international action to respond to a crisis that's been neglected for far too long. Thank you so much.
Thank you very much. Our next speaker is Muya Nyaundi from the American Bar Association, who will be discussing how the US Senate resolution impacts political prisoners and journalists, and how this can be translated into action and the actual release of prisoners.
Thank you. Thank you to the Oxford University Faculty of Law and to the students and the partner organizations that have arranged this two-day panel, and I'm honored to have been invited to contribute to the discussion. I have been asked to speak on how the resolution impacts political prisoners, journalists, and how this can translate to the actual release of the prisoners. As mentioned, I work for the American Bar Association Center for Human Rights, where I coordinate pro bono technical legal assistance to human rights defenders facing retaliation for their work. On the continent where I cover sub-Saharan Africa, we've conducted independent trial observation missions. We've documented fair trial violations We've undertaken fact-finding missions where threats to the independence of the judiciary and legal profession are taking place. We have also provided pro bono technical legal support on behalf of human rights defenders who are arbitrarily detained. This means submitting petitions to various UN and African Commission bodies. In 2017, the ABA monitored its first case in Cameroon. This was the case of detained human rights lawyer Felix Agbobala and several others who were arrested in relation to their participation to the 2016 protests. They were eventually released after 7 or 8 months. Since then, we've worked on various cases, mainly of journalists such as Samuel Wazizi, Paul Chauta, and we're currently working on the case of Wawa Jackson Nofo, who has been detained for over 3 years. This morning, I just got news that he was sentenced to 2 years. His case is a tragedy, and I'll explain why. He was arrested in 2018, accused of publishing secessionist information, and because he was charged under the draconian anti-terror law, he was denied. He wasn't entitled, automatically denied bail. Automatically denied bail. His case was postponed for over 3 years, primarily because the prosecution was not ready to proceed. They were not ready to present their witnesses. In the end, the prosecution did not present a witness. In the end, they didn't present a witness, but they did rely on witness statements that Nofo's lawyers was not able to cross-examine. They also relied on a confession that Wawa Jackson had apparently signed under duress. He had been detained for over 3 days with no access to his family and no access to a lawyer, and apparently physically beaten, essentially tortured. Now that he has been sentenced to 2 years, yet he had effectively spent 3 years in detention, is a travesty of justice. But the example of Wawa Jackson is just one of numerous cases of individuals who've been arbitrarily detained in relation to the Anglophone crisis, who have been denied due process rights. The case of Felix Agbobala, which I mentioned, and even Maurice Kamto, so many times we hear of the Cameroon security forces holding prisoners in incommunicado detention, transferring them from the Anglophone region to Yaoundé, where they are far away from their family members, not notifying them of the charges that they're facing, and then failing to present them before a court of law within 48 hours, which is mandated under Cameroon's own law and its regional and international obligation. As Resolution 684 rightly points out, since October 2016, the Cameroon government has responded to the crisis using excessive force and arbitrary arrests. But as many of my colleagues in explaining or trying to give context to the Anglophone crisis have done, mention has been made to over 7 million individuals displaced, 7 million individuals facing a humanitarian crisis, numbers of those who have been displaced and those who have been killed. But there are no specific numbers as to those individuals who have been arbitrarily detained. And primarily the reason of this is there's no documentation, because as I mentioned, a lot of individuals who are arrested, they're not informed of the charges they are facing. They are held in incommunicado detention and transferred out of the Anglophone region, making it very difficult for human rights organizations and for their family members to keep track of where they are. Essentially, the Cameroon government is waging a military war in the Anglophone region, but in addition, it has weaponized its criminal justice system to go against individuals who it perceives to be its enemies. These are activists, political opposition, teachers, lawyers, and academics. And in some instances, the security forces have taken advantage of the breakdown in the rule of law. And we've heard of situations where young men, just because they are young men and accused of being Amber boys because of probably the way they are dressed and the way they're looking or where they happen to be when they're approached by security officers, they have been arrested and threatened with the anti-terror law in order to solicit for the security officers to solicit bribes from them. So this is the scenario of arbitrary detentions in Cameroon. I'll now talk of specifically how Resolution 684 can help in releasing or calling for the releasing or impacting the release of currently arbitrarily detained prisoners. I'll start off by stating that in the first place, no one should be arrested for exercising their fundamental freedoms. Before I even go to people who should be released, in the first place, it's arbitrary, it's unlawful to detain somebody for exercising freedom of expression, association, and assembly, peaceful assembly. And the Cameroon government must be reminded of its obligations. The reason why there's the Cameroon crisis in the first place is because President Paul Biya's government failed to listen to the grievances that were being peacefully expressed by citizens in the Anglophone region. So the starting point is arbitrary arrests should cease. Cameroon's habit of arbitrarily arresting citizens must stop. And then we go on to individuals who are currently detained at the moment. We've had situations where when external pressure from international organizations and from international governments and the UN and the African Union has been exerted on the Cameroon government, they have released prisoners. I'll go back to 2017 when Felix Agbabala and several others were released. In 2019, Maurice Kamto and members of his political opposition party were also released. And then in relation to the national dialogue, about 333 prisoners were also released. So international pressure works, but it has to be collective international pressure. It cannot just be international pressure from one, maybe the United States of America and a few senators. It has to be collective from the region, the African Union, the African Commission, the United Nations, and especially France, which we have heard probably exerts the most leverage on Cameroon, but surprisingly or disappointingly is not as aggressive in holding Cameroon responsible for its human rights violations. Next, we've heard from a number of speakers who have indicated how countries such as the US, Canada, the Germans, the EU and the UK have been providing military assistance to the Cameroon government, especially in its counterterrorism strategy. But we know that an effective counterterrorism strategy also involves the prosecution and persecution of those who are accused of terrorism and financing terrorism. But we also know that the Cameroon government has misused its counter-terror laws to go against citizens peacefully exercising their democratic right. So instead of completely or solely investing in a military approach to the war against terrorism as a security partner, the US and other security partners must also invest in ensuring that Cameroon's criminal justice system, this is its judiciary, its prosecution, is independent and is not used as a tool of repression. I will add on to a point in that many of the accused or those who are arbitrarily detained, a lot of them who are not high profile do not have legal representation. And as such, they tend to fall through the cracks. There is need to help support local lawyers, local organizations, human rights organizations that provide pro bono legal assistance to these lawyers to be able to represent the thousands of faceless and nameless Anglophone Cameroonians that are currently detained to ensure that they do not fall through the cracks. There's one sad case of a young 14-year-old boy who spent 2 years in pre-trial detention. And then a lot of my colleagues have called for fact-finding missions, and I totally support that. But I would like to emphasize that these fact-finding missions should ensure that they go and visit the places of detention, and there are numerous places of detention, civilian prisons, also military facilities, as well as undocumented prison areas. The Cameroon government has allowed the Cameroon Human Rights Commission to visit the prisons, as well as a few religious organizations, but they've denied international human rights organizations the right to visit these prisons. The US government, in addition to the regional and international players, must pressure the Cameroon government to allow international organizations, and specifically the UN Special Rapporteur on Torture, as well as the African Commission Special Rapporteur on Prison Conditions, to be able to travel to Cameroon as soon as possible, given COVID restrictions, but to go and visit these prisons and where people are being arbitrarily detained. The final point that I would like to make is, especially following the previous presentations on US Magnitsky sanctions, The US resolution recommends that the State Department, Treasury Agency, and several of the US government agencies consider targeted sanctions against individual government and separatist leaders that are responsible for extrajudicial killings, torture, and other gross human rights violations. I wanted to specifically highlight that the US government and countries such as the EU, the UK, Australia, and Canada that have similar Magnitsky provisions must pay attention to judges and prosecutors who are responsible for or enabling the weaponization of the criminal justice system and making arbitrary detention possible. There is precedent for sanctioning judges and prosecutors that can be built upon. Last year, the US government sanctioned Venezuela judges and prosecutors who played a critical role in kangaroo courts, where the trials were marked by fair trial violations based on politically motivated charges. Similarly, the US also sanctioned 2 Iranian judges who presided over the prosecution and conviction of citizens who had been exercising their fundamental freedoms and sentenced them to death. Arbitrary detention, according to the UN experts, prolonged indefinite detention of individuals who have not been convicted of any crime is arbitrary, constitutes a form of cruel, inhumane, and degrading treatment, and even torture. Prosecutors and judges who enable the prolonged detention of Cameroonian citizens must be held accountable for the roles that they play. And I won't go into detail of how, of course, the previous speakers have talked of how sanctions work, and those who have sanctions regimes should be seriously considering and looking at judges and prosecutors. I know I said final point, but the final point is the US resolution calls for dialogue, that the dialogue and that the parties come to the table. But one of the challenges or obstacles of the parties coming to the table, especially from stakeholders, is that there are still leaders that are in detention, and they are not willing to come to the table as long as several of their leaders remain in detention. Earlier, I talked of the release of 333 prisoners arbitrarily detained, but those were lower level prisoners. There's currently some leaders, Anglophone leaders, who are serving life sentences, having been convicted by the Yaoundé military tribunal. And this is one of the reasons why dialogue has stalled. So if the Cameroon government needs to show a genuine effort towards coming to the table, and that also consists of releasing all those who are arbitrarily detained. I will end there and welcome any questions from the audience.
Thank you very much. The questions we'll have all at the end, just for time's sake. So for now, thank you. Our next speaker is Professor Franz Viljoen from the Center for Human Rights, University of Pretoria, who will be discussing what role the African Union can play in resolving the conflict.
Thank you. Thank you very much. I'm just at the outset to say from the Center for Human Rights, we are really very privileged and proud to be associated with the event, also as having been involved in this process. For myself, as the center, we have had the opportunity to also work inside the African Union, particularly with the African Commission on Human and People's Rights, to bring the issue of Cameroon into that forum. So in a sense, that's where our interest comes from. But let me talk then to the actual and perhaps the potential role of the African Union and its organs, and in the process refer also to ECAS, the Economic Community of Central African States, which is the sub-regional body which operates inside that region. I will look at 5 organs of the African Union and investigate briefly their roles. The first is the African Union Assembly of Heads of States and Government, together with the Executive Council and the Permanent Representatives Committee, the policy or the political organs. Now, the issue of Cameroon has been very conspicuously absent in these fora, in the Assembly. Until February 2020, we find that we have reference to Cameroon in the context of the national dialogue that had taken place. And clearly this is kind of a commendation, a recommendatory resolution or decision that the African Union Assembly takes, but it does insist on its chairperson, the chairperson of the African Union Commission, continuing the role that he has played in trying to find long-term solutions. So in a sense, how does one really explain this? I think if one looks in this period from 2017, we see that Cameroon is mentioned by the Assembly, but in the context of two particular issues. And the first is the Continental Logistics Base. That is for the African Standby Force. Douala in Cameroon is where this logistics base is located. And it shows Cameroon's very central position in peace and security stability within the African continent. It is located itself in that space. Also in terms of the multinational joint task force combating Boko Haram, that is where we find Cameroon being mentioned. So Cameroon is being mentioned as an important role player for the maintenance of peace and security more broadly in the African continent. And that clearly somehow deflects and insulates Cameroon at that high political level from the kind of criticism, or at least interrogation that one would have expected at that time. The second organ that I'm looking at briefly is really the African Union Commission. That is the kind of secretariat of the African Union with its chairperson. Now, perhaps here we've seen the most engagement in this conflict. We find that the chair, Mahamat, visits Cameroon in July 2018 and engages with Paul Biya, has a discussion, press releases, has discussions with other high politicians as well. So clearly it is framed in a rather diplomatic context, but we do find here the very specific call at that time, July 2018, for an inclusive dialogue from the chair of the AU. So one can see the influence potential there. We see then later on in November 2019, a joint visit by the AU chair together with the Secretary Generals of the Commonwealth and La Francophonie. So this kind of tripartite meeting takes place very much in a similar tenure as the previous one. So we see that that has been an avenue that can potentially be better explored, but the chairperson of the AU Commission is constrained because he in essence acts on the behest of the political organs and not really independently, but there is still room for maneuver, and we see that there has been some possibility there. The third organ is where we would really have expected the main impetus to come, and that is the African Union's Peace and Security Council. Now, it's similar to the UN Peace and Security Council, 15 members, and we again find that until after the inclusive dialogue, that there had been no time when the Peace and Security Council was seized with the issues around Cameroon. Now, it's kind of difficult to explain, except maybe to refer back to the logistics base and the joint action against Boko Haram, that again, Cameroon's cooperation and leadership role is required or kind of expected in terms of the broader African agenda for peace and security, and therefore a blind eye, as it were, is allowed in terms of what happens internally. But I think the answer lies also in the fact that Cameroon itself has been a member of the Peace and Security Council among the 15 for most of this period. So clearly that makes for a difficult kind of independent assessment. And the principle, somehow the subsidiarity principle of that the sub-regional body, ECAS, the Economic Community of Central African States, has to first resolve peace and security issues before the African Union would then take this up. And ECAS was very much not getting involved in this. And that lies in the nature of ECAS. ECAS is an 11-member grouping. Cameroon is kind of a hegemon in that grouping, again, influential together with Angola maybe and Rwanda. And if you look at the membership of ECAS, in principle, you have authoritarian democracies and states where really there is internal conflict already raging, such as Burundi, Central African Republic. So given the nature of ECAS, it is unsurprising, I would say, that ECAS does not engage itself with the conflict. And the blurring line there is, at what point does this subsidiarity principle now get, in a sense, replaced by the African Union taking primary responsibility? So if, in principle, the sub-regional body has to take responsibility for Peace and Security Council, there is not a clear developed rule to state if there is inaction, how do we propel this forward to the African Union? The fourth organ, very briefly, is the Pan-African Parliament. Now, it cannot make laws, formally speaking, but clearly it can adopt resolutions. It can bring attention to this issue. It has not done so at any time. There was, in fact, an effort. There was a petition before the PAP, but it had not been taken up. One of the reasons could be that in 2018, we see the election as the president, the speaker of the Pan-African Parliament, of a Cameroonian who I suppose one doesn't want to draw the lines directly, but one can also just see Mr. Nkodo Dam gets elected, and perhaps that was also part of a strategic positioning. If we look at all these bodies, we see the kind of importance to Cameroon to stay part of the decision-making levels of most of these African Union bodies, and perhaps trying that effort to insulate itself from the kind of criticism that would have come. Then lastly, where we would then also expect the action as it were to come is at the human rights level. We have the African Court on Human and People's Rights. Cameroon has accepted the jurisdiction of that court, but Cameroon has not accepted the direct access of individuals to that court. So without that direct access, the possibility of that avenue being explored has been, reduced to certainly minimalist possibilities. The second is the Committee on the Rights of the Child, because we know that children's issues certainly have been surfaced as well. Again, there is a complaints mechanism which could have been explored, but we find that no complaints had come to the Committee on the Rights of the Child. So again, perhaps a lack of mobilization, lack of knowledge, awareness, sensitization about that possibility. But the one organ that had played a role, perhaps more than others, is the African Commission on Human and People's Rights, which is the primary human rights watchdog of the African Union. And I'll briefly say something about the 4 parts of its mandate. First of all, the African Commission decided a communication, a case, a complaint, as far back as 2009. It was mentioned in the previous discussion, the Gunme versus Cameroon. Gunme, brought by the Southern Cameroonians, a case where it's on the one hand about self-determination and secession, but on the other hand also just about discrimination, exclusion from economic opportunity by the government of the Southern Cameroonians. The African Commission on the issues of discrimination and exploitation of the Southern Cameroonians finds in favor of the Southern Cameroonians. And in 2009 already, in its recommendations, it recommends, among other things, that these discriminatory practices be ceased, but also that an inclusive or constructive dialogue should take place. So the problem here is essentially that that recommendation of the African Commission had not really been amplified or taken up in terms of its political potential. The African Commission can also adopt resolutions. Again, resolutions, as we know, that are soft law, but they can push certainly the awareness and the agenda. There are 3 resolutions that the Commission had adopted in April 2018, November 2018, and recently 7 August 2020. And the essence of these resolutions is that the Commission had first asked for a promotional visit and later for a fact-finding mission to be conducted, well, by itself in the territory of Cameroon. The issue here is that for the Commission to undertake these fact-finding missions, it needs the consent of the state. So although in the public fora, Cameroon had said that it will welcome the Commission to visit and undertake these fact-finding missions, the modalities and the actual taking place of these missions had not taken place. The Commission also has a mandate around special mechanisms, and the previous speaker spoke about the special rapporteur on the conditions of detention, and clearly there is potential there that had also not been explored. Lastly, we have the state reporting function of the African Commission. That is when states regularly submit their reports about how they give effect to the African Charter, including the right to self-determination, minority protection, and so on. And then the Commission would adopt concluding observations to direct the state about how to improve the situation. Now, you could be a bit skeptical and call it audacious, but Cameroon, in fact, at the end of last year, submitted and presented its report to the Commission, something that states, generally are not necessarily all complying with very rigorously. That engagement, that interrogation, that dialogue between the Commission and the state of Cameroon now will result in concluding observations. Regrettably, those concluding observations have not yet been adopted and made public. This should happen now in the extraordinary session of the Commission that is taking place very, very soon. So in conclusion then, to say that perhaps we see the different dimensions of potential engagement by the African Union, and certainly we should explore ways in which this can be better explored and exploited. But we have, at least at the level of the African Commission, a number of steps that had been taken, and perhaps the challenge is to see how these steps that had been taken can be amplified by us all, amplified by civil society in Cameroon, or how these measures and resolutions can be linked better to international campaigns that are taking place, and also how, for example, these measures that are human rights, a kind of nature, could be better linked to the regional and national politics, because the extent of the violations are often such that a human rights framed solution has to be embedded in a broader political solution or dimension. Thank you so much.
Thank you very much. Our next speaker is the Honourable Dr. Sébastien Nadeau from the Foreign Affairs Committee of the French Parliament. He'll be discussing what the French are doing or not doing that has emboldened the Cameroonian regime in their line of action, as well as what the French can do to live up to their mantle as a country of liberty, equality, and fraternity.
Well, hello everyone. You can hear me? Yes? Okay, thank you. First, I want to thank the Cameroon Conflict Research Group of Oxford Law Faculty for all the work until today. And thanks a lot also to Effie Tambon for inviting me to this virtual forum about United States Resolution 684 today. Well, as a member of the Foreign Affairs Committee on the French Parliament, I look at the situation in Cameroon first. When I learned about Amadou Vamoulke, former director of the CRTV, this journalist is still in prison, which makes me deeply concerned about the freedom of the press in Cameroon. One might think that the injustice, the lack of humanity, and the prison policy of which Amadou Vamoulke is a victim is far removed from the subject that brings us together today and from the dramatic situation experienced by Cameroonians in the English-speaking region of their country. There are, yes, two very different subjects, but they are based on the same evils. When a dictatorship becomes harder and more centralized as its leader ages, like it is for Paul Biya, the first consequence is that the rule of law is violated everywhere. The Cameroonian dictatorship does not recognize the right to be different. For example, you can see with homosexuality is still criminalized in Cameroon. It also does not recognize the specificities inherent in the diversity that history, geography, and culture entail within a few individuals, or even in wider society, as in the case for Southern Cameroons. But in fact, this dictatorship, which wants to crush individuals, particularly those who do not conform, finds all its strength in the weakness of the international community. Cameroon has signed the United Nations Charter of San Francisco and many other international treaties that should bind it. If it is not respecting these treaties, then it is because the international community does not hold it to account. Within the international community, we can hardly count on non-democratic countries to remind Cameroon of its obligations. Also, given the country's past and the international configuration, the United States, France, and maybe to a lesser extent, Great Britain, Canada, and Germany should be active. Speaking about Southern Cameroons for France, I mean, for French government, I don't like to say about my country, but we have clearly a silence from France. And the resolution 684 insisted on this point clearly. France, with this, remains a key player, not yet convinced of the urgency and the need to act, in fact. But of course, we can talk about this good news. The transpartisan work in the United States Senate with this resolution shows a strong determination on the American side, which has since been confirmed by Anthony Blinken and Joe Biden himself. It can be added that many delegations from members countries of the United Nations Security Council have expressed their very strong concern about Southern Cameroon during the last sessions. Because of all of that, that's why this Senate resolution 684 is so important. Paralyzed for a long time, the international community is now in a position to find a new dynamic that would allow Cameroon to be put under surveillance, thus ending the cycle of violence in which the country finds itself. The French Constitution gives me a precise role in evaluating and monitoring the action of my government in terms of diplomacy vis-à-vis of Cameroon and the extremely violent conflict underway in the country. I realize that France is not playing the role it should and that it must revise its strategy as soon as possible. And I ask my government to do this. As a representative of the French nation, and it's a lot of citizens, in fact, because I also discussed with many Cameroonian stakeholders, and because of the situation in Southern Cameroon, I solemnly asked all my colleagues, MP and diplomats and GNOs that the situation in Cameroon has to be on the agenda of the next session of the Security Council of the United Nations, organized in March 2021 under American presidency. Wednesday and today I heard a lot about Magnitsky Act. And yes, it is very important as a tool in this action for peace, because to my mind, the international community must sanction all members of this Cameroonian government and the President Paul Biya first. Magnitsky Act is not something you find effective in French law. I don't know in all European countries, but you have something effective with eventually the same consequences around the Cotonou Agreement, treaty between European Union and Cameroon. And I think now it is very important to consider all the possibilities of individual sanctions to stop the violence in Cameroon and to start a sincere political process. Thank you.
Thank you very much. Our final speaker is the Right Honourable Emily Thornberry of the British Parliament, who will be discussing why the international community must come together to resolve the conflict in Cameroon. So, hello.
Hi. Thank you. Firstly, would like to thank everyone at the Cameroon Conflict Research Group for arranging this important conference and the Oxford Law Facility faculty for hosting it. Looking at the list of panelists that you got for today's event and the one on Wednesday as well, there were many names that I recognized, including my good friend Paul Boateng, who have been speaking out about what has been happening in Cameroon for a number of years now, long before the Foreign Affairs Committee in the United States Senate began taking an interest. And it is often a lonely, difficult struggle, speaking out about issues and banging the same drum every time you get the chance, hoping that eventually the world will start to listen. But for all of you today who have helped to lead that effort, I applaud you all and I thank you. The question put to me was, why does the international community need to come together to resolve the conflict in Cameroon? And I will address that question later in my remarks, but first I'm afraid I have to challenge the premise. Because the question I would ask first is not why the international community needs to come together to resolve the conflict, but whether the international community and major players like the UK government currently recognise that they have that responsibility. And let me explain why I asked that question. I started speaking out about Cameroon in my previous role as Shadow Foreign Secretary back in 2018. And I did so because I experienced one of those moments which just made me think about the British government. Either don't know what's going on in Cameroon or they simply don't care. But either way, it was my job to do something about it. And it came about in the June of that year when the Guardian newspaper ran a special feature on the brutal violence that was being committed by the Biya regime against the English-speaking communities and the refugee crisis that was resulting. I remember that they quoted a 36-year-old man in one of the refugee camps who described the military attack on his village and said that he'd fled along with everybody else. But like so many thousands of others, now he had no idea where the rest of his family was. Back home, he said, I live with my wife and 6 children, and now I don't know where they are. It was a deeply affecting report, and you would expect it to cause some concern in the British government. After all, these were English-speaking communities which used to be part of a British colony. This was a Commonwealth country whose government was responsible for the violence, and this was taking place in a region where the UK is the pinholder at the United Nations Security Council. But despite all that, on the very next day after that Guardian report appeared, the British Trade Secretary, Liam Fox, announced a £1.5 billion deal between a British national gas company and President Biya's regime. A deal with huge sensitivities for the Anglophone independence movement, given the location of the gas fields off the coast of the former southern Cameroon. A deal which, in the words of Liam Fox's press release, would, and I quote, generate a huge stream of revenue for Cameroon's public treasury. In other words, he was a ruler in President Biya in his 5th decade of autocratic power, with a personal wealth of at least $200 million, engaged in a systematic campaign of violence against the English-speaking community in his country. And all that the British Trade Secretary could do was boast about doing trade deals that would only enrich him further. And as I say, I ask myself the question, does the British government not know, or does it not care? And then we move forward 2.5 years to the 1st of January this year, when the US Senate came together and unanimously approved the resolution that we're discussing together. A resolution which could not have been clearer about the actions for which the Biya regime was responsible, including, I quote, torture and sexual abuse, massacres and burning of villages, use of live ammunition against protesters, arbitrary arrests and unlawful detention, forced disappearances and deaths in custody, attacks on journalists, and the regular killing of civilians, including women, children, and the elderly. The Senate resolution noted approvingly the decision of the Office of the US Trade Representative to terminate Cameroon's access to do preferential trade rights due to, I quote, persistent gross violations of internationally recognized human rights. And I have to say, I stop and think, this is the decision of the Office of the US Trade Representative. under Donald Trump. Anyway, and finally, the state resolution urged members of the international community to join the United States in a strategic collective effort to put pressure on the government of Cameroon, including, I quote, the use of all available diplomatic and punitive tools. And yet, despite that appeal to the international community and despite all the evidence on which it was based, on that very same day, the same day that the Senate resolution was passed, the UK government chose to bring into effect a brand new preferential trade agreement with the Bayer regime. And when I saw that, I no longer needed to ask the question, do they not know or do they not care? Because I'm afraid the answer is obvious. And so here is the problem for me. We can debate how the international community needs to work together to respond to the Senate resolution and broker talks towards a political solution. And clearly that is a vital debate because it is the only way to achieve a lasting peace. However, we've got to be realistic about the current position we're in, where a government like the UK's, with historic commitments to Southern Cameroon and current responsibilities as the pen holder at the UN, which should be at the heart of a drive for peace, is instead turning a blind eye to the problem and signing trade deals with President Bayer instead. So, as vital as it is that we take action at an international level, I will be totally honest with you and say that my main focus right now is on trying to persuade the UK government and my colleagues in the UK Parliament that they need to start caring. They need to start caring more about this. They need to start caring about this more than offshore gas fields and preferential trade deals when it comes to Cameroon. Let me close by saying this. At some stage in the coming weeks and months, there will need to be a debate in the House of Commons about that Christmas deal with Cameroon. We haven't had it yet because 8 weeks after it came into force, the government still hasn't published the trade agreement and indeed claims that it still hasn't been formally signed. But when they do, I will demand a debate in Parliament and I will insist that the UK government defends its decision to do a trade deal with the Bayer regime despite the atrocities the regime has committed and despite the Senate resolution urging us not to do this. And when that debate takes place, I will ask the organisations and individuals taking part in our discussion today and all of those watching online to make your voices heard and to say to the British government, very simply, if you know what is happening in Cameroon, how can you refuse to care? I hope that debate will have an effect, and I hope that it will lead to a statement as powerful as that we've got from the Senate. And I hope once all the individual members of the international community are persuaded of the need to act, then we can properly take this discussion forward to the international community as a whole. Because we must come together and we must do that. Thank you very much.
Thank you so much. And thank you to all the other speakers as well for speaking today. We'll move on to the questions. The first question is for Emily. The first question is, thank you for raising the trade deal. Who is really benefiting from the UK trade deals with Cameroon? And do the people of Cameroon benefit at all from these deals? And how do you think that the UK as a nation benefits from negotiating oil deals for UK companies when they are structured with offshore ownership and thus pay very little, if any, tax to the UK? Sorry, I think you've been muted again. I've just asked to unmute, sorry. I've asked to unmute, so if I think.
Oh, I'm muted. I was thinking you're doing the answer in mime. Look, I don't know what the point is. I don't know what's in the trade deal. It isn't published. I'm not even going to get started on all of that, on the lack of democratic accountability when it comes to trade deals in the UK. But essentially, they're signed on behalf of the Queen, and so we don't have any right to insist on a debate. And there have been a large number of trade deals signed recently, and we haven't seen them yet. So there is a certain level of arrogance within the British government and the executive at the moment, and we seem to be a very long way away from the kind of, you know, the siren call of taking back control. There seems to be a lot of control being given to the executive of the British government, but Parliament seems to have very little control over this at the moment, I'm afraid. But I get the points that are being made. I understand what's being said, and of course, you know, there are times when one can't just simply assume that because a British company may have benefited from a particular deal, that the British people will have benefited from it. Of course, you know, the assumption is too often made.
Thank you. Another question is, will the Shadow Cabinet call for the Selection Committee on Foreign Affairs to investigate and report on the atrocities in Cameroon, as it did in the cases of crimes against the Rohingya minority in Myanmar?
I think that we're at the moment, my plan is this, right, is that they can't not publish this deal. I mean, the fact that they haven't published the deal for 8 weeks, I think shows that they realize that this is profoundly embarrassing. They realize that Thornbury is on the rampage, you know, and just will not have this. You cannot just sign up deals on the very day that the Senate are essentially congratulating Trump's trade secretary for what they're doing on Cameroon. And there is Britain yet again as an outlier on this. But they've agreed a deal. They need to publish it. When they publish it, I will be demanding that we have a debate in Parliament. And I think that's the first step before we take it any further. And actually a debate on the floor of the House of Commons, I think, could be something, and particularly with support from people who are concerned about this issue, who can get in touch with members of Parliament and say, this is something you should care about. This is a former British colony. This is part of the Commonwealth. This is a country that we seem to have a close relationship with. You know, there's a great deal of British investment going into. You know, you can't turn a blind eye anymore.
Great, thank you so much. Our next question is to Kyra Fox. Just ask her to unmute. The question, sorry, does the language of genocide help or hinder advocacy efforts to bring attention to the conflict in Cameroon?
That's a very interesting question, and I'd be curious if any other of my colleagues on the legal front would want to weigh in as well. Genocide is a powerful word, and as I kind of said at the beginning of my presentations, mass atrocities themselves are extremely rare. Genocide is also extremely rare, and as we've seen in political debates in the United States and elsewhere, governments are hesitant to use the term in a number of crises that perhaps legal scholars would say definitely qualify as genocide. In the case of Cameroon, I don't think that legal analysis has been done. And I think when it comes to advocacy, it's quite important to remember, at least in the US context, a genocide designation doesn't actually require the US government to take any actions following that designation. And so while it can be an important tool for advocacy to mobilize groups, I think it's really important to remember that regardless of what we call the crimes that are occurring in any one place, governments have an obligation to prevent mass atrocities, period. And in the United States, there is, legislation as such. And so I think it's important, at least on the US side, and I can't really speak to other types of advocacy, to remind governments of this responsibility. And perhaps it's helpful to avoid the debate of whether or not it's genocide and focus on preventing the crimes that are ongoing against civilians, and focus on practical steps that governments can take to do that. That would just be my take, but if other colleagues have comments, I'd be eager to hear.
Thank you. Our next question is to Nicholas and Morgan. Is there a scope not just for independent countries to each issue sanctions, but for an international body like the UN, given its targeted smart sanctions?
So there's definitely scope for sanctions, not just at national level. So the EU sanctions that we referenced briefly would be a way for there to be a coordinated framework for sanctions against human rights abusers. That said, our area of expertise falls much more within the Global Magnitsky Act and how sanctions are imposed under that system. So I can't really speak to whether or not there's a possibility for coordinated targeted sanctions at a UN level, but I'd be curious to hear whether or not any of the other panelists have views on this.
Yes, thank you. Yeah, that works. So I was just going to comment on the genocide issue. I think what is interesting is just that obviously in the context of the Rwanda genocide, the whole concept is a very, very emotive and brings to mind certain historical realities. But in terms of the African Union's constitutive act, its constitution, there's the famous Article 4H, which allows the African Union to intervene in a member state. And that's why the African Standby Force essentially is there for situations where a member state is unable or unwilling to protect its own nationals. And the legal terminology there is, it is exceptional and would only be allowed in a case of genocide, crimes against humanity, or war crimes. So again, I think the emotive value of genocide is certainly important, but I think the criterion of crimes against humanity, which is perhaps easier to prove, easier to get consensus around, not, if we have to juxtapose those two, I think 4H, which is this important kind of possibility of the African Union intervening, that door is opened, even if it's a determination of crimes against humanity. Thank you.
Thank you very much. The next question is actually for you, Sue. If you would unmute again, I'll just ask you to unmute again. So last year, the French Cameroon government made 2 advances to start talks with certain Southern Cameroon leaders in detention in Yaoundé. Why has this move not been encouraged and followed through by the African Union or the UN?
Well, yeah, I suppose, my whole discourse showed the kind of forces that are at play, why we find that the African Union deflects in a sense. I think the bottom line is, although we all embrace the idea of African solutions, African problems, but it seems like because of this principle of subsidiarity, we could say that in Central Africa, the notion is Central African solutions to Central African problems. And that is the role of ECAS, the body that is closer to the localities and where people are situated. And I think it is that principle and its kind of a mute acceptance that stands in the way of progress being made. So I know it's a bit of a legalistic answer, but I'll just reiterate that. And I think it is to be taken seriously as a principle and interrogated and dissected in terms of at what point does this principle no longer hold? And is there not only moral, but also a legal responsibility on the African Union to deal with the issues itself?
Thank you very much. The next question is for Muya. You mentioned the importance of an independent judiciary in Cameroon. What methods should individual governments implement to pressure the Cameroonian state into ensuring this independence and resilience?
Thank you. There's no one solution in terms of which you can promote the independence of the judiciary. there are many ways, but the first and foremost is how judges are selected. And currently, under Cameroon's laws, the judges are directly selected by the president, as well as they are dismissed. The president can dismiss them. So by virtue of the direct selection, you have it. There's no separation of powers between the executive and the judiciary, which would then, you know, in a normal scenario where you have separation of powers and checks and balances between the executive and the judiciary, that line is blurred. And hence why, even though we celebrate when President Paul Biya instructs judges or prosecutors to drop charges on accused and arbitrarily detained people, that just shows that there's no independence of the judiciary, where a president can literally pick up the phone and call military tribunals and say, drop the charges. Equally, he can pick up the phone and say, prosecute John, Simon, and Peter. Whereas prosecutions under regional and international standards, prosecutors and the judiciary are supposed to be independent. So I'll start off by saying that there needs to be an overhaul in how judges are selected. And then I think one of the primary reasons that led to, or the concerns of the Anglophone region was the imposition of Francophone judges over Anglophone judges, and judges from the civil law system over the Anglophone system. But I do know that last year, the Training Institute of Judges hired more judges and trained more judges on the common law. So that's just one minor improvement in the implementation of the criminal justice system, and they're deployed to the Anglophone region. So I think there is room for working with the Cameroon government and institutions, the local bar associations, also strengthening the independence of the legal profession, because the legal profession is the first call to holding judges accountable. And if you've got a strong legal profession, judges as well are picked from the legal profession. So if you have a strong legal profession and a strong bar association that can hold judges accountable, then you have a stronger judicial system. So there are multiple ways in which the independence of the judicial system can be promoted. So.
Thank you very much. The next question is for Dr. Nadeau, which is for what needs to be done to effectively get the French to forego their interest and use their leverage on the Biya regime?
Well, excuse me, can you repeat your question?
Yeah, sorry. The question was, what needs to be done to effectively get the French to forego their interests and use their leverage on the Biya regime, is the question.
Well, I need 2 hours to answer this question. In fact, France has interest in Paul Biya's regime. The problem is at the moment, France don't want to touch to anything because they are afraid of something new, and they think they will lose something if something new is coming. That's the matter. And of course, you have, and it is said in the resolution, you have the question of economical matters, and this is the first reason, I think. And after, because I think our diplomacy is particularly silent in all these sort of matters you have in another country in Africa. It is to say, when there is a problem with freedom, with human rights, in fact, you have many things in the speech, but nothing concrete. And that's why I asked clearly to take measures, sanctions, and I asked it to my government to do something real, not only in the speech. But it's a very complicated question, I think.
Thank you. We'll go back to Emily Thornbury for final questions. The first one is, what other remedies are available if the trade deals are never published?
Oh, they have to publish them. They can't have a deal without publishing them, but they can drag their heels. So as I say, there's embarrassment, I suspect. I mean, who knows? But I suspect there's embarrassment, and so they are putting off doing something about it. They've agreed it. They've got a memorandum of understanding implementing that agreement, but they claim that they can't publish it because it hasn't been signed. It just needs someone to sign the bit of paper. But, so something's going on, but they will need to. And we've put in written parliamentary questions as to why we haven't had it before us yet. And they say it's because then they haven't signed it. And then obviously the next question has been, why haven't you signed it? And we're waiting for an answer on that. But they won't be able to, they can put it off, but they will have to publish it in the end. We can't have international agreements that are secret. At least we're not supposed to.
Thank you. The next question is, why is the UK seemingly not ready to get off the fence and put more diplomatic and economic pressure on the government of Cameroon? Are its hands tied by so-called economic interests?
Well, personally, I think that it's linked to our current situation. Of course, it is. We've left the European Union. As predicted, we're having a little bit of a bumpy ride. The current government believes that the downside of leaving the European Union is more than made up for by our ability to be able to make trade deals with other countries around the world. It isn't as easy as they seem to have first thought that it was. But they need to make up the shortfall, and I think that it is symptomatic of a kind of almost desperation to fill the holes that are left as a result of leaving the European Union, and we in the opposition won't have it. We believe that there are certain British values that we should uphold, and there should never be an excuse not to stand up for human rights.
Thank you very much. I think that's all the questions we have time for. So thank you so much for speaking again and for answering all the questions. I will hand over now to Effie Tembon, who organised this whole conference both on Wednesday and on Friday. Thank you so much, Effie, for doing this. It's been incredible. Thank you for having me be a part of this as well. So Effie, you'll unmute. I'll let you finish.
Thank you so much, Rania. I have the honor to say the final words to bring this Oxford conference to a close. However, the movement for peace and justice will not stop until there is peace and justice. I want to express special gratitude on behalf of the organizers and the oppressed people of the Southern Cameroons to all the speakers. You inspired us to fight for human dignity, peace, and justice. And to quote Nelson Mandela, to deny people their human rights is to challenge their very humanity. I want to thank the Oxford University and the Cameroon Student Society at Oxford for hosting this conference. And special thanks to the co-organizers, the Center for Human Rights at the University of Pretoria, the Gold International Human Rights Clinic at the University of Southern California, and the Oasis Network for Community Transformation. Thank you. And a very special gratitude to my two colleagues, Dr. Wallace and Rania. Without the hard work you put in, this would not have been possible. Thank you so much. To all the participants who registered for this conference and to those who are watching online, we want to say thank you. We will continue to work together to bring another very dark page of our history to an end and justice for the people. Great Britain and Canada peacefully opened the door for the people of Scotland and Quebec to decide their future. But a brutal, senseless, horrific, and unnecessary war was declared on the people of the Southern Cameroons that wanted the same. And former UN Secretary General Ban Ki-moon once declared, human rights are for all of us, all the time, whoever we are and wherever we are from, no matter our class and opinions. We are grateful to the US Senate and the staff that worked so hard to pass this resolution. You sent a message to the oppressed and despairing people of the Southern Cameroons who suffer continual attacks from both the Cameroon military and armed combatants that there is hope. Sexual violence has become the order of the day in the Southern Cameroons. A young generation of children denied the chance to live and play. More than 1 million kids who have lost 4 years of schooling. The elderly, the sick, and children burned in their own homes. A human catastrophe, pain, trauma, and loss that words cannot describe. We all owe it to them to continue to fight for peace and justice. These atrocities are a reminder that the kind of hatred and hate speech that led to Rwanda and Srebrenica still exist. These atrocities demonstrate the weakness and failures of the international system. The hate speech that demonize and dehumanize a people, leaders who promote violence. We cannot fail to challenge what is going on before things get even worse. The military solution is not a real solution. The real solution is a political solution where the parties to the conflict come together around the same table. Silence is not acceptable. We must continue to have the courage to stand up and to be the change we want to see. Thank you very much, and God bless you.
Thank you. I'll just end the meeting now, but thank you so much one more time. Thank you.